AYPO Real Estate Principles of Real Estate 2 Newest Actual Exam Complete Questions and Correct Answers, Verified Answers. Question 1. What does the Federal Trade Commission, FTC, specifically require regarding truth in advertising? Advertisements must be approved by a local board of realtors. Advertisements cannot contain statements likely to mislead reasonable consumers. Advertisements must use a minimum of 3 high-resolution photos. All real estate ads must be written in at least 2 languages. The FTC rule focuses on consumer protection. It mandates that advertising must be truthful and non-deceptive. In real estate, this means that a licensee cannot make claims or omissions that would lead a reasonable consumer to a false conclusion about the property, its features, or the terms of a loan. Question 2. Which of the following is not considered an effective way to prevent errors in a real estate practice? Thorough disclosure to all parties. E.N.O. Errors and omissions, insurance. Meticulous documentation and record keeping. Regular staff training and education. E.N.O. insurance is a financial safety net that covers losses after an error has occurred. It does not actually prevent the error from happening in the first place. Effective prevention strategies include transparency, disclosure, keeping a detailed paper trail, documentation, and staying current on laws, education. Question 3. Which agency is responsible for the regulation and management of mold remediation in the state of Texas? The Texas Real Estate Commission, TREC. The Texas Department of State Health Services. The Texas Commission on Environmental Quality. The Texas Attorney General's Office. Mold remediation is a health and safety issue regulated under the Texas Occupations Code. The Texas Department of State Health Services, DSHS, oversees the licensing of mold assessors and remediators and sets the standards for how mold should be handled to protect the public health. Question 4. To provide constructive notice of ownership, where should a deed be filed in Texas? The Secretary of State's office in Austin. The TREC headquarters. The county clerk's office in the county where the property is located. The local municipal zoning office. Filing a document in the public record provides constructive notice, which legally assumes that the public is aware of the transfer of title. Texas law requires that real property instruments be recorded in the county where the land is physically situated to be effective against third parties. Question 5. How is marketable title defined in a real estate transaction? A title that is currently in the process of foreclosure. A title free from defect and significant threat of litigation. A title that can only be transferred between family members. A title that has no existing liens or easements of any kind. Marketable title, also called merchantable title, is a title that a court would compel a buyer to accept. It is free from reasonable doubt or clouds. While it may still have encumbrances, like a standard utility easement or a mortgage that will be paid off, the parties are aware of them, and they do not threaten the buyer's future ownership rights. Question 6. If a Texas county clerk accepts electronic documents for recording, they are legally required to phase out all paper recording within 12 months, charge a premium fee for electronic filings, continue accepting paper documents and use a single index for both, only accept electronic filings from licensed attorneys. Under the Uniform Real Property Electronic Recording Act, URPRA, technology is encouraged but not exclusive. County clerks who move to digital systems must still accommodate paper filings to ensure accessibility for all citizens. Furthermore, they must maintain a unified index so that a title search finds all documents regardless of how they were submitted. Question 7. Why does a mortgage lender require a borrower to obtain a mortgagee's, lender's, title insurance policy? To protect the borrower's down payment. To ensure the loan is enforceable by protecting against unknown title defects. To provide a life insurance benefit for the homeowner. To guarantee the property will increase in value. Title insurance is a contract of indemnity. If a title company missed a prior lien or a forged deed in the chain of title, the insurance pays for the legal defense or loss. Lenders require this because their mortgage lien is only valid if the borrower actually owns the property. If the title fails, the lender's security for the loan fails. Question 8. In the event of a failed depository institution, what provides constructive notice of the transfer of a mortgage or land interest? A public announcement in a national newspaper, a verbal agreement between the banks, a recorded affidavit or memorandum in the real property records, an email sent to the current homeowner. When one financial institution takes over another, often facilitated by the FDIC, they must ensure the chain of title for their thousands of mortgages remains intact. Texas law allows for a memorandum or affidavit to be recorded in the county records to serve as legal notice to the world that the interests have been transferred. Question 9. Which type of estate is defined as being of interminable length, existing for a lifetime or forever? Leasehold estate, non-freehold estate, freehold estate, estate at sufferance. Freehold estates are interests in real property that involve ownership for an uncertain duration. These include fee simple, forever, and life estates, for the duration of a specific person's life. This is the highest level of interest an individual can have in land. Question 10. What is the legal term for an individual who dies having made a valid will? Intestate, testate, escheat, administrator. A person who dies testate has left clear instructions, a will, for the distribution of their property. This differs from intestate, where the person dies without a will and the state's laws of descent and distribution determine who inherits the property. Question 11. What is a minimum general requirement for an instrument to qualify as a valid deed in the state of Texas? It must include a recent professional appraisal. It must contain words of conveyance. It must be signed by the grantee, buyer. It must be written in both English and Spanish. A deed is the legal instrument used to transfer title. To be valid, it must be in writing, name a grantor and grantee, include a legal description, and most importantly, contain words of conveyance granting clause that clearly state the intent to transfer the property. The grantor must also sign the deed. Question 12. The right of the government to take ownership of privately held real estate for the public good is known as escheat, adverse possession, eminent domain, taxation. Eminent domain is one of the four powers of government, PETE. While the government has the right to take property for public use, such as roads or schools, the Fifth Amendment and the Texas Constitution require that the owner be paid just compensation for the taking. Question 13. In Texas, a license holder must advise a buyer in writing to do which of the following when an offer is signed? Always offer 5% below the asking price. Wait for the seller to provide a free home warranty. Have the abstract examined by an attorney or obtain title insurance. Choose a lender recommended by the brokerage firm. Section 1101.555 of the Texas Real Estate License Act, TRILA, mandates this disclosure. Because title issues are complex and legal in nature, agents are required to warn buyers to protect their investment by either having a lawyer review the abstract of title or by purchasing a title insurance policy. Question 14. Under Texas law, who is legally permitted to draft or prepare original legal documents such as deeds or deeds of trust? Licensed real estate sales agents, professional surveyors, licensed attorneys, title company escrow officers. Preparing legal documents for others is considered the practice of law. To protect consumers and prevent unauthorized legal advice, Texas strictly limits the drafting of these instruments to licensed attorneys. Real estate agents are permitted only to fill in the blanks on promulgated, standardized forms approved by TREC.